right. So I got off to a little late start today. Gonna try to get a little bit of a lawyer workout in. I didn't bring my special little TV. Hopefully somebody's around this morning. All right, so today we're gonna get a little bit of a lawyer workout in. It's about 05:44 and it is cold out here. Beautiful day in Summerlin. What's going on, Jody? So the other day I had a buddy of mine refer me a slip and fall case. And I wanted you guys to understand how difficult those cases are, especially when the stars don't line up. So a lot of you guys may or may not know I'm a lawyer licensed in California and Texas. But I also do, some civil rights, and I got my start in appellate law and criminal law, but my expertise is personal injury. So I figured I would try to help you guys because I'm starting to get a lot of people referring me cases who are on my channel. And I want you to know that not all injury cases are the same. And for all of you people on my channel, because a lot of you guys are older, hey, what's going on, Steve? Yeah, it's got to be freezing. Race gas, yes. Jody, love seeing you guys. Oh, and BZ helped me install Nightbot, which is kind of cool. So if you guys are interested in picking up a copy of my book, you can do that as well with the Nightbot link there. Kind of dope. I kind of like it. Anyways, I wanted to let you guys know what's going on with personal injury cases when it comes to slip and falls, because they're one of the most difficult ones that you can do for a lot of reasons. Proving negligence is the hallmark, is the main way that you prove any kind of case like a slip and fall or any of those types of matters. Hold on, let me get this thing on my head a little better. There you go. All right, so in order to prove negligence, you have to prove duty, breach of duty, actual cause, proximate cause, and damages. So everybody owes a duty of reasonable care, and that comes from natural law, believe it or not, the social contract. The duty of everyone to behave in a reasonable manner so as not to harm someone. Has nothing to do with socialism, has nothing to do with communism. It's simply a social contract. It was talked about by guys like John Locke. It was talked about by philosophers like Thomas Aquinas, who was one of my favorites, Adam Smith, all those guys. And it's just a duty to behave reasonably. And when you don't behave reasonably and someone is damaged as a result of your unreasonable behavior, you have the right to sue for money damages. Now, it used to be, before that, we would have people out there trying to take each other's heads off, basically. A pound of flesh. That's how it used to be. People would go after you for a pound of flesh. And as a result, over the years, over the centuries, the law was changed in order for people to be able to not have to lose their lives if they did something stupid or something that was an accident. And even if it was intentional, rather than suffer the ultimate penalty, loss of life, they would be able to, people could sue them for damages. Now, it doesn't always work out. We saw what happened with O.J. Simpson after he slaughtered his family. He was able to escape to Florida and not pay because Florida apparently has a rule that you're not allowed to enforce judgments out of state. So it doesn't always work out for everyone. But anyways, let's get into slip and fall. Hey, what's going on, Life Under? Good seeing you, man. Hey, Rami, what's going on, brother? So we're going to talk a little bit this morning about slip and fall cases, so you guys can learn a little bit about that, especially you old codgers out there, which I'm getting to be one of you. So negligence is one of the main thing you have to prove first is whether or not a property owner behaved negligently. And that is going to be proven, number one, by showing notice. Did they have notice of the dangerous condition on their property? And now in a grocery store, for example, you can't always show that. Let's say that there was some water on the floor, but it had only been there for a few seconds, right? Well, then you wouldn't be able to prove notice and you would lose. And you can argue constructive notice. That's what I would argue. I would say, well, you knew or should have known that that area where they clean the fruit or the vegetables is going to be wet all the time because water is dripping or whatever. And therefore you have constructive notice. And another way you can do it is to argue that they failed to make reasonable inspections. Like if they know that it's an area where there's going to be water on the floor, that they needed to inspect that area, every 5 minutes or whatever, and they didn't do it. And the way you do that is you do that with the inspection logs. So you'd have to get that through discovery. You'd have to file a lawsuit and get that. You can't just get it from them. So the notice requirement is the biggest one with slip and fall cases, especially in California. It's a big deal. But you do have the ability to argue constructive notice or actual notice. Actual notice is where, it's obvious. It's so open and obvious that the manager could have seen it. The problem is, if it's open and obvious to a manager, it's also open and obvious to you. It's also open and obvious to you, a victim, right? So if you're the victim, you knew or should have known that it was there. And because of that, your own negligence can bar that claim. So that's another big problem with slipping and falling at like a Walmart or a Costco. Like if you saw that there and you just kept walking through it and you fell and got hurt, well, that's your problem. So they'll argue that. Now, you can also argue if it's like a 1-inch little thing coming up out of the floor, like a nail head or whatever, that it's a trivial defect. It's such a small and trivial defect that it's not reasonable for you to sue them. So that's another bar to suing a property owner for a slip and fall case. Now, the other issue, a really big issue with slip and fall cases, is that most people don't, well, number one, you have to give notice to the store owner, right? And so most people think, well, I'll just tell the manager and I'm good, I've made a complaint. No. The manager will keep that complaint and you'll never get a copy of it. Even if you try to take a picture of it, they'll try to snatch it away from you. So you make your own complaint and you hand it to the manager. Don't rely on the manager or the store to help you in any way, shape, or form. That's not going to happen. You're going to be in real trouble. And they'll lie about it and say it never happened. So that is another big problem people have, is just like with the police, they think the government's there to help them. And that doesn't happen. Good seeing you, Life Under and ABC, Rami. Yeah, what's up, Unc? Right on. By the way, I am suffering through some serious injuries right now, so I'm limping a little bit, and I don't have my gimbal with me, so forgive the bounciness. All right, so there you go. So those are some of the main problems that you're going to have. Now, a real super duper problem that people are having is they don't take the ambulance to the hospital. So now you've broken the chain of relationship. You're no longer, as soon as you leave that store and you don't take an ambulance to the hospital, I would say you've got about a 90% less probability of getting any money for that case. And typically people don't even go to the hospital for 2-3 days a week. And after that, your case is exponentially worth far less money, because now the defense attorney gets to argue that it could have happened somewhere else, right? They can argue, oh, you did it during a baseball game. They'll start looking at your social media posts. They'll prove that you were out and about after the incident, and you're screwed, right? They'll do what's called sub rosa. They'll surveil you. They'll find out any little thing they can, that you went shopping, whatever, and then you're screwed. So that's another big problem with these slip and fall cases, is people don't immediately get medical care. Now, another big problem with slip and fall cases, in California in particular, is the damages. People think that if they slip and fell and they sprain their ankle or they got a bruise, that's going to entitle them to a bunch of money. Unfortunately, that's not true. Well, Rhine Labs getting run over in a crosswalk is a totally different deal. That's cases like that are the cases where I've been able to get my clients millions of dollars because it's much more easy to prove. And we'll get into that in another video, but I'm glad we talked about this morning because this is how I support my family. I mean, I do these cop watch videos because I know you guys like it and because I'm a guy who got beat up by a cop. So I empathize with you and I want to help you understand the law about that as well. But yeah, if you want to learn about how to protect your family after they get hurt by someone, I'm your guy. So what's going on here with the slip and fall case is if you just have like a small injury where it's like a bruise, even though it's terrible and it could put your wife or you out of commission for weeks and it makes you pissed off, the cost of me bringing that lawsuit, I have to hire a premises liability expert, thousands of dollars. Just like, proving a police abuse case, I'll have to hire a use of force expert, right? So you do all that, and if you don't have big enough damages in the form of medical bills and stuff like that, you don't have a chance. So you're really left in a bind in a situation like that. Here, I'm trying to find a rock because I didn't bring my phone stand this morning because I'm going to go do my little lawyer workout for you guys to motivate you guys to get to the gym, for crying out loud, or at least go to the park. No excuse, guys. It's 5:56 in the morning and I'm on my way to go work out with you guys. So you have no excuse. All you disgusting fat bodies, get off your butts and get to the gym or go to the park or do something or take care of yourselves, especially you men who are providers. Because if you don't, you're looking at heart disease and all these other problems coming your way. Hey, right on, BBC Johnson, life under. So here I am. I'm going to walk over to the park right now, walk through this landmine where all the dogs poop everywhere. Now, if you have minor injuries, it's that dog don't hunt, because the amount of money that it's going to cost me to bring that claim is more than I'm going to be able to recover for you. And the chances of winning, unless you took an ambulance to the hospital, slim to none, almost impossible. And that's why I always tell everybody, tune into my channel. So in the future, at least you know the law and you know how to protect your rights. Most people don't know this, and then they hate lawyers because, oh, the lawyer didn't get me money, the lawyer this, the lawyer that, but it's your fault for not listening to your lawyer. That's really what it boils down to. So, hey, look, I can probably set my stand right here. Hold on. Let me see. Hope you guys can see me. Yeah, so I'll just do my regular stretching routine. Now, there's a couple other issues that you want to think about, but it's mainly not getting to the hospital right away. And again, if you don't have serious injuries in a slip and fall case, it's really, really hard to prove. Now, there is one thing that's interesting about these slip and fall cases at grocery stores, is if they have a lot of signs like advertising. Well, that's considered to be a distraction, right? That could be a distraction, and that could give you the basis to sue. But again, unless you took an ambulance to the hospital, you're going to be in a tough spot, or at least had a family member take you. And that manager's report that you made is worthless because you don't get a copy of it. And the only way that I can get a copy of it for you is to sue. Now, to sue, it's going to cost me close to $1,000 just to file a lawsuit. And if you don't have medical bills, well, how do you expect me to get you any money? Because your damages are based upon not just your pain and suffering, but your medical bills. And there's a direct relationship between your medical bills and your pain and suffering. So hopefully you guys can see what's going on. It's really, really dark right now, but I'm going to try and zoom you in on a different workout this morning. All right, so let's get into the workouts. So, and I'm going to talk to you guys about all your questions in a minute. So the back is your second largest muscle group, all right? Your back is your second largest muscle group. The more muscle your body has, the more efficiently your body burns fat. All you people who run, all you're doing is tearing down muscle, and you're speeding up your metabolic rate for about 72 hours after the time that you ran. So great, it does speed up your metabolism, but it doesn't burn your muscle as efficiently as having muscle. It doesn't burn your fat as efficiently as having muscle. Still early, guys. So I'm gonna show you what I will do to try to build that back muscle, because that's the most, besides your legs are your first largest, the back muscle, your lats, are really gonna burn fat for you. So let's check out another routine that I do on my back that will kind of blow your mind. Well, hopefully you guys saw that. So that is the equivalent of a reverse row, but upside down and vertical. And that is one of the best ways to build that back muscle. And you can see I'm just doing it at a playground, at a public park. So you don't always have to go to Powerhouse Gym or whatever. Yeah, hoorah. And then of course, we always want to get the push-ups in, right? And the way I do that is I do reverse incline press. You see that slide right back there? This one happens to be pretty cool because it has a place for me to put my hands, but not necessary. Let's take a look. Shit. Whew, man, what a butt kicker. Oh. And of course, you always want to stretch. Super big deal. Since I have some problems with my calves, one of the ways you can stretch them is like this. See my rear foot there. Oh boy. So I'm not going to give you all the Japanese names for all my stretches, but there you go. Hey, how's it going? All right. There's one dude out here with his dog. Clearly a legit person trying to make it happen. Man, I feel old, guys. See, I'm so old that I saw these guys play live at the Olympic Auditorium when Glenn Danzig still was lead singer. All right, so the notice requirement is going to be one of the biggest problems with a slip and fall case. And that's going to require actual and constructive notice. Now, here's another issue. I brought notes with me this morning. Wanted to make sure I gave you guys a good show. Holy crap, it looks like I got a super chat or something over here. Holy crap, thanks, Steve. Hey, look, you know, Steve, I appreciate that. I got a $10 super chat. So, see, look, he's even doing some push-ups now. Normally, I never see him do that. So, see, this is the effect of coming out here and staying after the task, is you want to motivate other people because we're all God's children. And sometimes it just takes another person to do it. And we're all like herding animals. We're gonna fall in line and try to stay in shape. So I'm hoping I can motivate y'all to get out here and look after yourselves. I'm gonna try to do one more set of pull-ups, and then we'll hit the road. Yeah, I'm doing a podcast out here, man.
Huh?
I'm doing a podcast.
Oh, really?
Yeah, all my friends, I'm showing them how to work out in the morning.
Oh, I see.
Yeah, to stay motivated. One more. Whew. Man, I am out of shape. That just killed me right now. Well, hopefully you guys didn't see all my tattoos all over my belly, but I am a Marine and my background is judo and jiu-jitsu, so peer pressure, man. If you've ever been to the mats, Brazilian jiu-jitsu especially, everyone's covered with them, so it's just part of the culture. But man, I certainly have gotten out of shape over the last couple of years from being a lawyer, but no excuse. You have to stay after the task. You have to take care of yourself, because if you don't put yourself first, you can't take care of other people. So it's another reason why I like doing these shows, so I can motivate you guys to look after yourselves. It's selfish not to look after yourself. All right, now, let me see what else. Another issue with slip and fall cases is going to be statute of limitations, but that's with every personal injury case. If you don't bring your lawsuit within 2 years in California, and again, there are exceptions, but typically it's 2 years. If it's a government claim, which it rarely will be, but it could be, like a defective sidewalk, right? You slip on that or trip. You'll have only 6 months to file a government claim. And then from the time you file your government claim, you'll have, man, I kicked my ass. That last set of pull-ups really wiped me out. If you don't file that government claim in time, then you waive your right to sue the government. Now, if you're a minor, that 6 months clock generally won't start ticking until you reach the age of majority. In California, I guess for sexual predators, it's whenever, because the government lets them do whatever they want. But for everyone else, it's going to be 18. That's a little joke for the San Francisco values of California. But so typically, man, another beautiful day in Summerlin. Whew. So the statute of limitations will be a problem, but again, unless you guys are taking an ambulance to the hospital and running up a lot of medical bills for a slip and fall case, most lawyers won't touch that with a 10-foot pole. And the reason being is because it is almost impossible to get any money for that case for your client. And the lawyer is going to be spending everything out of their own pocket to try and bring a case and conduct discovery to get all the things that you should have gotten when you actually were injured. So what are those things? Well, number one, proof that you made a report, because they're going to steal that report from you. So get out your phone and snap a picture of it. Snap a picture of the manager. Get the manager's name. See, I know it's hard to remember. So for you men, know this in advance. Be prepared like a Marine. Know that every day you go out, it's a battle. And there's a potential that harm could befall your family. Understanding this in advance makes you better prepared. The other thing is, it's another case It may have been changed by statute or by a later case. I think it has, but the principles still apply. The case is called Buehler versus Alpha Beta. I think it's Buhler or Buehler. You can Google it. And basically what that says is not only did you have to fall or slip, but you have to know what it is that you fell or slipped in. So if you say, I just fell, I don't know what I fell in, you lost. You're not going to go anywhere with that case. You're done. Do not pass go. So you should take a photograph of it. Now, you know, a lot of the defense attorneys and jurors may be like, well, how were you able to take a picture of it when you were in so much pain or whatever? But I can argue that later because, hey guys, because typically I won't have to file the lawsuit. See, what you're doing by getting evidence in advance is preventing me from having to file a lawsuit. And the defense attorneys love it when you file a lawsuit because they bill by the hour. So it's no skin off their teeth. The one who suffers is you and your lawyer. And if you have an unreasonable client, which there are a lot, they're always going to blame the lawyer. Oh, the lawyer charged too high of a fee, the lawyer this, the lawyer that. Well, you agree to your fee in advance. I won't touch a case unless I get at least 33 1/3%. And people will say, yeah, but all you did was send a letter. How does that make it worth it? Well, then go ask your next door neighbor to send a letter for you and see if you get the same result. You pay me for my experience of 20 years as a practicing lawyer and my reputation as being a pit bull. So for you simpletons who think, oh, I should only pay you 10 or 20 or 25%, go F yourselves. Go find some idiot who will represent you for less and get less money. I don't care. Most of my clients are inactive Marines and veterans, and they hire me for precisely the reason that most of you will end up hiring me, because I will rip the face off of any defense attorney or insurance company who messes with my people. And that's what you're paying me for. You're paying me for my fierce reputation and my experience as a relentless savage. And you can say, oh, but you just sent a letter. Oh, but you just did this. No, I worked for over 20 years and I earned a reputation to where a letter with my name on it is worth more than platinum or gold in some cases per ounce. And that's what you're paying for. So don't be a simpleton. Don't be unreasonable. And I'm not saying that just about hiring me, but with any lawyer. Look at their experience, knowledge, and skill, and their reputation in the industry, and pay them accordingly. Just like if you're a plumber or you're an electrician, you don't want someone complaining about your hourly rate when you showed up on a Sunday when their basement was flooding. You don't want to bicker with some woman, with a weakling husband who lets her bicker with you. What you want is somebody who understands that you sacrificed your life to make it to where the stars lined up to get there at that particular point in time to keep them from losing their home. And if you're a good plumber, you're also gonna bring fans with you, and you're gonna let them use your fans and blow out that basement. Just an example, guys. I'm a little bit of an unorthodox attorney because my background is a blue-collar construction worker. So just want you guys to understand, in a slip and fall case, it's not easy. And if you're capable of finding a lawyer good enough and you did all the things you needed to do, like take an ambulance to the hospital, get medical records showing a severe injury, and that's the next thing on the list. Severity of injury is super important. If you just have bruises, scrapes, etc., maybe it's better just to give them a bunch of negative reviews on Google or something, because the amount of money it's going to cost you to go after them, first of all, no lawyer is going to take that case because he already knows the dog's not going to hunt. But if you have a broken knee, if you have torn ligaments where it requires a surgery, even if I have a hard time proving liability, in other words, that you were there, that You know, they were aware, they had actual or constructive of the danger. If I have a hard time proving that, and spread your brains out all across the floor like eggs, damages will find liability. And that's a term that we use in my industry a lot, or my profession, is that damages will find liability. If you have enough damages, the insurance company has actuarial tables and risk tables and risk evaluators, and they'll go, damn, they've got millions of dollars in potential future damages here and pain and suffering. So let's go ahead and offer them something to get out of this case. And so that's why I tell you guys, damages will often find liability. Now, it's not a slam dunk, but it gives you a much higher probability of winning your case if you have extreme damages. So the main problem that I have with most people is they're like, well, you know, you won't take my case, you're a shitty lawyer. That's the, you know, it's unbelievable, the simpletons that I deal with. It's like, no, I won't take your case because I want to keep you as a friend. Because a shitty lawyer will take shitty cases and they'll lose every time. And my experience, knowledge, and skill tells me that this dog doesn't hunt. Now, if you don't have a case that I think, in my opinion, warrants moving forward from a lawyer's perspective, I'll still teach you how to file a small claims case, try to help you that way. If you go to the michaeleline.com website, I have articles about how to bring a small claims case in California. So I'm not going to leave you in the lurch either way. But what I don't want is for you to try to disparage me or my profession for not taking a case that's not going to get you any money. Most people, especially you civil rights auditor types, think that you have these bulletproof cases that are going to make you millions of dollars. Most of the time they won't, because of your attitudes, especially if you're caught on tape being a belligerent jerk. What's going to end up happening is, even though the jury might be sympathetic to you, they're going to think this person was a jerk. I'm going to find in their favor, but because I don't like them as a person, I'm not going to give them, I'll give them a buck, I'll give them $1. So what ends up happening then is the only person who's going to get some money is going to be your injury attorney, because he gets his attorney's fees, which you don't get. And even then, civil rights cases, because of Stephen Yagman and what he did back when I was just starting out, you're not going to get any money. He's not going to get any money. So Stephen Yagman, I'll tell you a little bit about him. He was a guy who did a lot of those Rampart cases. I met him a couple times. I tried to get a job externing for him, but I'm glad I didn't, because he ended up getting locked up. So what he would do is he would get all these civil rights cases with shitty defendant or shitty plaintiffs, people have an attitude, people who think they know everything. I'm sure you guys know plenty of guys like that, or girls, and want to argue all the time and try to tell you everything about the law that they don't know. Like Abe Lincoln said, it's better to be quiet than open your mouth and be considered a fool than to open your mouth and remove all doubt. But so what Yagman did is he went ahead and he would sue, files government claims, he would sue, and then settle for $1, right? Because he knew his clients weren't going to get any money, or go to trial and get $1 by the jury. And then he would get millions of dollars, hundreds of thousands or millions, I can't remember what it was. It was case by case. And ultimately, he ended up getting in a lot of trouble. And because of him, they changed the civil rights laws to where somebody like me who wants to bring a claim for you now doesn't even want to touch the case, because we realize that you've got a major attitude, that you think you know everything because you saw some video on YouTube, and you don't want to listen to your lawyer. You want to argue with your lawyer and make your lawyer's life hell once you sign on the dotted line. So people always say, well, hey, why didn't you try to get that case? I'm like, well, did you watch the video? That person was out of control, and nobody in their right mind on a jury is going to give that person money. And so as much as I empathize and sympathize with those people, want to help them, the best way that I can help you guys is to teach you how to be better when you're interacting with law enforcement, when you're interacting with people in public, if your goal is to bring a lawsuit. Because if your goal is to bring a lawsuit and you have an attitude like that, it may help you with views and likes and subscribers on YouTube, but you're not going to win any money in a case. Very rare that you would. And you don't engender yourselves to the judges or the juries or anybody like that. So anyways, I appreciate it. I'm going to take a look at your questions. There's always another case. That's right. There's always another case. Hey, Rami, good seeing you. Beck, yeah. Jailed, maced while I was hanging because they did listen. Water was turned off. Scolded me in the shower. Should I sue? Yeah. You just keep on walking past these guys. And a wise man once said nothing. Just Willie. That's right, brother. A wise man once said nothing. And my brother did a slip and fall out of the tub and asked me if I should sue because the towel rack failed to brace him. And I said, no one expects a towel rack to brace a fall. That's true, Zach. That is true. So a towel rack, that's going to be based on the reasonable person standard. And that's the last part of what I wanted to talk to you guys about before I head out for the day, for my regular day job, is comparative negligence. Now, not all states are comparative negligence states, but California is. So California is what's called a pure comparative negligence state. So if a reasonable person believes that a towel rack is going to save them from a fall, a jury would weigh that based upon what a reasonable person would think. And typically, most people know that a towel rack is just bolted into the wall with some screws. So as a result of that, they would offset your recovery based upon your negligence, your comparative portion of negligence against the landlord or the manufacturing company who makes or installs the installer the towel rack. And so as a result of that, your recovery will be offset. So you will probably lose that case or maybe just get a couple of bucks. And that's called pure comparative negligence. Now, Texas has a different law that says, see, there's people going to school now. Texas has a different law that that even if it's 1% your fault, you lose everything unless you prove you had the last clear chance to avoid the injury. But anyways, we'll get into that in another time. I do appreciate you guys joining me. I don't know if I'm going live tonight, but hopefully you learned something. This is not a situation where I talked about cop watching or anything, but it's equally important because as my channel grows, I'm getting people reaching out to me with cases and potential lawsuits. And look, I want you guys to understand that I want to help you. And even if I can't take your case, it doesn't mean that I'm an asshole. It doesn't mean that I'm a bad lawyer. It just means that I have enough experience to know, after doing this for 20 years or longer as a paralegal, that some cases just don't hunt. But it doesn't mean that you don't have something, and it doesn't mean that I'm not going to give you the information you need to try and do something, even if it means calling the Department of Consumer Affairs to try to get the safety regulations changed, OSHA, whatever it might be. It doesn't mean that I don't like you as a person. It doesn't mean that I'm a bad attorney. It just means that I know what's going to get you paid and what's not. And certainly if you're one of these people who thinks that I'm being a jerk or whatever, well, I don't want to have you as a client. And it is high winds, just Willie. My goodness, I am freezing my butt off. Now, also, as an aside, the most important thing that I want y'all to remember about life, go out and exercise. There's no excuse for you to be laying there right now with a big old belly, with a hangover. If you're going to play hard, work hard, all right? I'm not suggesting that you go out drinking every day or smoke weed or whatever, but if you do, work hard, play hard, work hard. Get out and work out, guys. Take care of your bodies. Be part of Team MPE. Square yourselves away. If you have a wife and kids, make sure you stay in shape for them because they're relying on you to take care of them. That's your job as a man. So with that being said, I appreciate everybody coming out to my show today, Life Under. And I really appreciate hey, Age Go. Thanks, brother. Zach, Steve Conkler, Race Gas, Ophanim. And I'll look at all your comments later and give you some more answers. But if you have questions about personal injuries or catastrophic injuries, if you're in a car or a motorcycle accident, you have a 99% greater probability of winning that case than you do of a slip and fall. Now, some slip and fall cases, I've won millions of dollars for my clients, but those cases typically involve where there's been a video camera and we were able to capture that video because I was able to immediately send out what's called the demand for preservation of evidence letter. Now, unfortunately, most of you guys don't call me for weeks after you or your family are still hurting. And by that time, the videotape's been recorded over. So besides taking an ambulance to the hospital, the very first thing you do is you call 1-833-LETS-SUE. Write it down, 1-833-LETS-SUE. That's my phone number. And I'll be able to have somebody at my office at least get your information so I can get back with you. Because the sooner you get a hold of me, the sooner we can get a demand for preservation of evidence letter out. Now, if you can't get a hold of me or you want to handle it yourself, go to Grok or ChatGPT, it's all you got to do, and type in demand for preservation of evidence letter sample for your state, and at least do something to try to protect your case. I'm not trying to give you legal advice. I'm telling you as a brother, an uncle, whatever, like this is one of the best ways to preserve evidence in your case, because now if that store tries to destroy that evidence or record over it, you can use that letter that you sent them against them. But if you didn't send it in a timely fashion, you don't have a case. So with that being said, guys, make sure to like and subscribe. Make sure to save, double tap that screen. Again, thanks for the super chats and likes. If you want to pick up a copy of my book about how I became a lawyer with no law degree or law school, I sell digital versions of my ebook on PayPal, and BZ Watchdog helped me set up this chat bot thing, and it keeps on pumping the PayPal link. And Life Under, I need to get you your copy too. Reach out to me on Twitter, Life Under, with an email address, and I'll have my daughter shoot you over one of the digital copies. But anyways, hopefully I can motivate you guys. Thanks, Rami. That's right, 1-833-LETS-SUE. And Chili says 1-800-CHOKE-DAD. No, that's the one that I have for all the single ladies, just kidding. But anyways, guys, make sure to like and subscribe. Semper Fi, do or die. I wish you guys the best. I may or may not go live today, but I'm super, super grateful that you joined me this morning for the lawyer workout. And for all you disgusting fat body lawyers who think that you don't have time to work out, well, it is now 6:26. I was out the door at 5:40. I got to do 2 sets of pull-ups. I did about, 20 or 30 push-ups, did some light stretching, and now I'm back. I just did more than 99% more of you lawyers, and I feel good. Now, it wasn't the best, but at least I did something, and that's more than I can say for you guys. So again, Semper Fi, do or die. Good seeing you, Arthur, and I will talk to you guys soon. All right, bye.